to this computer. Done.
Thank you very much.
No problem. Okay, so let's introduce the speakers. I won't be speaking too much, but I'm Paul Thomason from Enable, Director of Strategy and Innovation. But the main speakers today will be Kieran, who is the Senior Content Manager at LexisNexis, and will be certainly contextualizing the international content through some recent regulatory challenges and privacy and cybersecurity space. And then we've got Andre van der Merwe. So Andre leads our IRM practice at Enable, and Andre will effectively be showing a live demonstration showing the system of action from ServiceNow with the content from LexisNexis and making it all real. And then time permitting, we'll have some questions at the end. So please submit them on the chat. Otherwise, we have some questions ready to go that we think you'll find interesting, but certainly submit them as we go. So let's press on. Really set the content. Regulatory compliance is one of the top 3 priorities for CEOs. I think that's been a consistent for some time, and ever more so with some recent events globally. But there's definitely a need for real-time or near real-time information over static reporting. So, with the build-up of volume of these compliance controls and requirements, spreadsheets and manual methods of emails is really just not as fit for purpose anymore. So there's definitely a lot of time being used to manually merge these spreadsheets and chase this data. And as time moves on and more regulations come, then we've got to look at a more automated solution. So we've got to get ahead, and certainly one of the challenges is to receive non-legalese guidance, and that's definitely a big plus point for LexisNexis, which we'll look at in more detail. So today's session, we're going to highlight some of those changes in an ever-moving landscape around that international privacy. And indeed cybersecurity legislation. We're going to look at GDPR and other regulatory burdens as well. It's not exclusively GDPR today, but also look at and showcase how that content comes together in the system of action, which is today's purposes ServiceNow, and Enable is an elite ServiceNow partner, and certainly ServiceNow is ranked as a very leading platform around integrated risk management. So before I hand over, just the last note from myself, it was, what was the reason for the partnership between Enable, LexisNexis and ServiceNow, and really, to put it into one slide alone, there's certainly a lot of siloed IT, risk and compliance systems. They're siloed from the processes that are automated in your organization, and those processes are executing, and they stand in another silo of information and so forth. So what that means is that still the attestations are very manual. They're really a task that you have to go and execute yourself. As opposed to automated, where I can link that into the process itself and automate those controls. So equally, there's a lot of inconsistency there of workflows and certainly intermittent monitoring of those risks. So at the end of the day, the reporting is a big burden and transparency is not clear. So you're really not arming your first line of defense adequately to do the job that they're tasked to do. So really that gave rise to the ServiceNow IRM capability combined with LexisNexis, which really hits the sweet spot. So with ServiceNow, the IRM capability sits across all of the processes, whether that be from HR, IT, finance, indeed legal, or whether it's your B2B or B2C capability, or anything else that you onboard into that workflow platform. So that then enables you to automate those controls into the process, pulling back that information in real time. And that's basically been the foundation of the partnership for some time now. As I say, we enable an elite partner with ServiceNow, and we have a specialized practice led by Andre in this capability. And we've been experiencing benefits, as it shows there, with obviously the real-time reporting, the massive reduction in that manual reporting, and certainly the accuracy is hugely improved, and certainly a much better transparency into your compliance status, and decrease effort managing those new regulatory events, which we'll certainly talk about and show today. So enough from me. Over to Kieran. Kieran, thank you for coming today.
Thank you for that introduction, Paul. And I will try and drive now. I'll just swap over to my screen so that we can continue. Okay, see if that works. Okay. Have we successfully switched drivers?
You were successful. Well done, sir.
Fantastic. All right. So hello, everyone. Good day. So to kick off this part of the presentation, I'd just like to give a quick refresher on the GDPR and its key concepts. So the General Data Protection Regulation is a requirement set under EU law for data protection and privacy in the European Union. Now, widely considered to be one of the world's leading benchmark for establishing a data protection framework. It came into force in May 2018. Now, the General Data Protection Regulation applies to relevant businesses that have an establishment in the EU, offer goods and services to individuals in the EU, or monitor behavior of individuals in the EU. Now, the whole point of the GDPR is to protect the data of EU citizens and residents. So it applies to organizations that handle that kind of data, regardless of whether they are EU-based or not. So if you, for instance, have a commercial website that tracks cookies or IP addresses of people visiting your website, or have started to market specifically to EU-based customers, then technically you fall within the remit of the GDPR and could be held accountable for your tracking of that data. Now, the GDPR sets out 7 key principles, which sit at the heart of its data protection framework. Compliance with the spirit of these general principles is a fundamental element to upholding strong data protection practices. Fail to uphold these basic principles, and you could be vulnerable to substantial financial penalties. Now, these principles include that individuals' data must be processed lawfully, fairly, and transparently, that data is collected and processed according to specified purposes, that data is kept accurate and up to date, and that there is appropriate security on the data. Now, there are a number of key issues and themes that come out of the GDPR, and most of them are core tenets of privacy laws around the world. And we'll look at some of those in a moment. Now, these concepts aren't really new concepts. They've been around for at least 2 years, and sometimes even further back than that, but they are critical to understanding privacy compliance in the modern era. Now, first of these is there are certain core rights of data subjects that need to be upheld, such as the right to information portability. Organizations also need to be careful how they manage consent, as consent won't be valid if there is a clear power imbalance with the subject of the data. Next is that data can be transferred outside the EU if the country of destination is considered adequate, as determined by the European Commission. Now, if the country is not adequate, then the transfer can only take place if appropriate safeguards are in place to protect data privacy. Then you've got privacy by design, which essentially means protection of data through the design of technology and projects. Now, this was a well-known concept before the GDPR, but the regulation specifically recognizes the right and provides a framework for enforcement. The GDPR also makes it mandatory for organizations to conduct privacy impact assessments for certain high-risk processing activities. Some examples of what could be considered high risk include use of new technologies, processing sensitive information, or if it could result in physical harm to the subject individuals if it were leaked. Now, these assessments are an important concept for privacy protection and should form part of an organization's overall risk management planning processes. Finally, the GDPR prescribes a requirement for organizations to appoint a data protection officer for most public bodies, or if the organization processes a large amount of sensitive information or is particularly far-reaching on individuals' rights. Now, this officer has a number of duties, including working towards compliance with relevant laws, raising employee awareness, and collaborating with authorities. Now, for a law commonly hailed as the gold standard, it's no surprise that many jurisdictions around the world have worked to implement similar privacy requirements. And broadly speaking, recent developments touch upon the principles and key concepts enshrined under the GDPR. Now, we of course don't have time to go into detail on each and every change that's taken place in the last few years. That would take an eternity, but on screen you'll see a few examples of recent privacy changes from a selection of jurisdictions, which I'll go through a couple of those. So staying in the EU, individual countries have been iterating their local privacy laws, while the Union as a whole has moved towards further restrictions on privacy. As part of its digital single market strategy, the European Commission has been working on its draft e-privacy regulation, which is intended to act alongside the GDPR by specifying how this framework will be applied to electronic communication services. Now, it's unclear when or even if actually this change will be adopted, but we can expect more of this kind of gap-filling activity going forward. Then you've got the EU Court of Justice decision from July, known in general parlance as Schrems II, after the person who brought the original complaint before the court. Now, the Schrems II decision made a number of key findings. Now, most critical of which is that the Privacy Shield, which is a framework for regulating data exchange between the EU and the US that many organizations rely upon, is invalid. Now, any organization that relied upon this framework will now need to consider whether data transfer can occur under appropriate safeguards, such as standard contractual clauses and binding corporate rules. Now, this will have particular implications for UK organizations who are also preparing for the Brexit transition and updating their privacy frameworks to refer to both UK and EU regimes, depending on their data transfers. In the United States, there is no central federal privacy law, though perhaps we will see one in future. There are, of course, a number of general privacy requirements for certain industries, such as for banking and finance, but certain US states have been taking the lead in privacy regulation and implementing laws comparable to the GDPR. Probably the best example of this is the California Consumer Privacy Act, which protects the data of Californian residents. Now, other states have followed California's lead and created their own comparable privacy frameworks, such as New York, which is on the screen, and of course, Massachusetts. In the Pacific, we've seen a lot of our own privacy changes. In Australia, we've had the introduction of the notifiable data breach scheme, which protects, which requires publicization and regulatory notification of major breaches of personal information. We've also seen the introduction of a consumer data rights framework in the banking sector, which will progressively roll out to other sectors of the economy. A review of the Australian Privacy Act is also underway, and it's easy to anticipate that this will cause a major shake-up to the data protection and cybersecurity landscape in Australia over the next few years. And finally, just a few days ago, actually, New Zealand's new Privacy Act took effect, which implemented a lot of the best practice concepts from around the world, such as a breach notification framework and cross-border protections. There's also been a number of changes around Asia, and you can see some of those on screen. The one I'd like to call out today is China's draft personal information protection law, which was released for consultation in October. Now, this framework will be China's first comprehensive law on the protection of personal data and will significantly impact organizations with operations in China or that might be targeting China as a market. Now, I've talked for a solid while now about a lot of very technical privacy laws around the world and how they're progressively changing. Now, they all share key similarities and differences, and in an era of global transfers of personal information, it's a major struggle to uniformly and consistently protect personal data. But that's not the only challenge that organizations face. With the susceptibility to increasingly sophisticated cyber attacks and diversification of the kinds of data that organizations come into contact with, this leaves organizations exposed to major consequences if and when they experience a data breach. Now, in the past year, Facebook and Google, perhaps the most prominent data holders in the world today, have suffered significant financial penalties, rising to billions of dollars in the Facebook case. But it's not just financial penalties that need to be taken into account, particularly for countries that don't have large fines for breaches, and this is the case in the new New Zealand framework. It's the reputational harm from negative media reporting and the damage that causes on the perception of consumers that has the potential to impact an organization and its ability to be successful into the future. Loss of trust, in fact, may translate to a loss of business. Then you've got the challenge of ensuring continuous compliance. Regulatory change is happening faster and faster, and in a globalized society, you'll be looking to changes taking place far from home in understanding what you need to actually comply with. In the short term, this difficulty at ensuring change management is compounded by the public health directions and orders associated with the COVID-19 pandemic. Now, in the regulatory compliance world, around half of all alerts that we've sent out this year, in fact, has specifically referred to or relate to those ongoing requirements. There's also an increased propensity for laws to take effect contingent on other laws. And what I mean by that is commencing when an entirely separate piece of legislation is proclaimed to take effect. It sounds complicated, and it is complicated. Now, taken together, regulatory change management is a massive challenge. In the privacy space specifically, we've seen just how much change is already taking place in the international landscape. We're also likely to see consumer privacy requirements evolve in a post-COVID environment due to increased surveillance, the existence of new digital records of sensitive health information, and facilitating data collection in future potential health emergencies and crises, so adapting to future crises that may occur. Now, depending on an organization's activities, the future potentially holds a lot of change in the privacy space as we look into the future. With a review of the GDPR on the cards, potential standards for blockchains and distributed ledger technologies in 2021, and ongoing legal changes to account for AI and machine learning, the one thing we can be sure of is that privacy compliance will continue to change repeatedly and rapidly. Now, where do we come into this discussion? At this point, it's worth summarizing the regulatory compliance solution. So LexisNexis Regulatory Compliance is a legal obligations register and alerting solution that combines regulatory content with technology to empower you to take control of your compliance obligations. We have in the first instance, a very broad Australian portfolio covering a variety of industries, including financial services and the government sector. Most importantly, and most relevant to today's discussion, we are now live internationally in 7 other jurisdictions. So China, Hong Kong, Japan, New Zealand, Singapore, the United States, and the United Kingdom. We've gone live with 4 modules, which is anti-bribery and corruption, anti-money laundering and counter-terrorism financing, privacy and data protection, and cybersecurity. And it's those last 2 that, of course, are most relevant to our current discussion. Now, on the screen now, you'll see a breakdown of the sorts of topics and compliance sources that we cover across these modules. Each of the jurisdictions I just mentioned has its own separate module, targeting the local obligations and the local legal landscape and sources. However, we push for consistency between these modules. So they're structured in a similar way to show comparisons between privacy and cybersecurity concepts. And as I alluded to earlier, these concepts are quite similar between different jurisdictions. So as you can see, the topics include many of the ideas that I've already dealt with, such as cross-border transfers of personal information. And the legal landscape also refers to many of the sources that I've already dealt with. Now, we emphasize the importance of expert authorship across our entire content set. We have a team of highly experienced content developers that create, deploy, and maintain content. Our content developers work with legally trained technical writers to convert a comprehensive set of requirements under legislation and regulation into a concise set of obligations. And we also work with legal and technical experts who assist us by providing deep subject matter expertise on their fields of study. We provide practical content across all of our modules. Doesn't matter which module you're looking at. Now, the example on screen gives you a breakdown of an obligation, this one from our Singapore module. And all these obligations across our whole portfolio follow this consistent structure. From the short description of the obligation for setting a question or for testing compliance, to a concise practical summary of the requirement, in this instance, how to meet cybersecurity risk management obligations. Now, obligations also identify remedial activities to achieve compliance and set out the consequences expressed in local currency of compliance failures. But of course, these obligations are kept up to date as compliance sources and legal requirements change. Regulatory compliance is also augmented with an alerting function, which helps you understand on an ongoing basis how your obligations are changing. With a consistent structure, alerts have unique codes for tracking purposes and are linked to related obligations in your subscription. Now, much like the obligations, which I referred to earlier, they summarize the change and set out the practical impact and actions for organizations. Now, that last bit was a very quick run through of how we do what we do and what it is that we do from a content perspective. But it's really through the integration that we see all of these concepts come to life. And so on that point, I think I'll hand over to you, Andre, to elaborate on that integration piece.
Thank you, Kieran. I'll also just quickly do my screen share. So from an integration perspective, the capability that we have within ServiceNow IRM is to ingest and effectively import, your regulatory content in context of your instruments, your specific obligations, and also your regulatory events. And because of the integrated nature of the ServiceNow's, solution, where applicable, those obligations and regulatory events can be applied and assessed in context of any changes in your policy environment, making sure that your compliance posture is maintained and those attestations do happen, as required by your regulators. Also identifying the relevant risk, statements associated with these obligations and instruments, including the ability to also manage vendor risk directly. We also have an audit and assurance module that allows us to independently test, compliance to certain obligations, within ServiceNow. Again, that gives a lot of capability for your risk line 2 and even, line 3 risk within the business. From a business continuity perspective, all those obligations that speak to the more technical, requirements and, obligations from a data, perspective, and making sure that you can actually be a resilient organization when there's, a disaster. Again, you can link that within the system directly. And as mentioned previously, we now have access to the international content, which is what I will also now quickly demonstrate. Just quickly do my screenshot. Good, just checking that you can all see my screen.
Yes, we can.
Good stuff. So from a compliance reporting perspective, we have in excess of 20 reports available already from a LexisNexis, dashboard and reporting perspective. In context of, for instance, your instrument tracking and monitoring reporting, we have the ability to identify any new instruments, that has been uploaded into the system. Also, any instruments that's been updated recently. We can also manage different sources of, content providers. In this case, LexisNexis and UCF, including also being able to report on the different instrument types within your instrument library. And from a instruments by, relevant category, for instance, as part of this demonstration, we have, for the Asia region, 2 specific, instruments that we will showcase. From an obligations management and reporting perspective, we have the ability to identify and report on those obligations with high impact penalties. And that's part of that obligation management capability that we have within ServiceNow, and being able to really identify and manage your high inherent risk obligations, and also those obligations that still have a high residual risk associated with them. We can also track the updating of obligations over any period of time. The normal report tracks it for 90 days. That's easy to configure to meet your specific requirements. And we also have the ability to do a full obligation compliance breakdown to fully understand which specific instruments and obligations we are adhering to within the organization. From a regulatory event and assessment reporting perspective, really ease of use is, one of the big, wins within this capability. The ability to integrate and also understand any new regulatory events, that's applicable within the organization. Also identifying any open high impact assessments. So we have a combination of the ability to import the specific regulatory event, but also to perform an impact assessment, which is also, a big one within an integrated system. And from a click-through perspective, and I'll quickly show you this, we can, for instance, very quickly, by clicking on a specific part in the report, open up and identify any of those regulatory events directly. And here we can see, as part of our demonstration, one of those regulatory events in context of the Singapore, PDPA, Act specifically. So what I'll do to showcase how we actually represent the specific data structures, from LexisNexis within ServiceNow. Let me start with how we, display and allow the, management of instruments within ServiceNow. And this is all automated. So you can effectively establish your instrument library through the press of a button. And, that press of a button will import all your subscribed, instruments, and also those related obligations. And after that, you'll also receive your ongoing specific regulatory event updates. You can manage, first of all, the specific source of your instruments, the category. In this case, selection was Asia, any reference URL, the instrument type, and also valid, periods of this instrument. You can also see that you can manage and identify all those related obligations, linked to the specific instrument, including, any regulatory events that's been identified by LexisNexis. Now we import that on a daily basis and allow you to then review the regulatory event if it's applicable to you, and also then perform an impact assessment. So what I will demonstrate is one of the obligations, related to our instrument, specifically to the Singapore Privacy and Data Protection Act. So this is how we, manage obligations within ServiceNow IRM, and allow people to, again, quite effectively, use the really good information that you get from LexisNexis in context of the type of obligation that you have imported and that you're now assessing, from an applicability perspective. You can also assign ownership to specific obligations in the organization, part of the implementation of this capability is also the setup of necessary groups and ownership. You can also manage and track the last review dates of your specific obligations. You can also then perform a risk assessment around the materiality of this of risk associated with this obligation, and also identify any specific impacts and penalties specific to this obligation when you do not adhere to it. You can also perform an inherent risk rating and residual risk rating, and the system also allows us to automatically aggregate and understand our specific obligation compliance score based on the work that happens within the compliance module. So one of the key benefits of the ServiceNow IRM solution is that you can definitely establish your instrument register, your obligation register, and also your regulatory event register. But you can do so much more with ServiceNow IRM. You can also link your obligations directly to your internal control environment within ServiceNow. From a specific data structure perspective, which is what we allow, from a obligations review perspective, you have that ease of use and legal, non-legalese content available directly from LexisNexis in context of practical guidance. You also then have access to the questionnaire description, again, reflecting back on what Kieran showed us. So we actually follow a similar structure and layout, on this form. You'll see that where we have a lot of text in a field, we can actually quite easily, just drag that specific, part of the field, and it will actually allow us to open up and read all the specific information, including remedial actions associated with this obligation, any specific consequences associated with this obligation if you do not adhere to it, including your specific directional description from LexisNexis. And then one of those, big benefits, because this is an integrated solution, using ServiceNow IRM, we also have the ability to show the hierarchy between specific, parent obligations and even specific sub-obligations. So we also manage that parent-child relationship, including the ability to, integrate and bring in those regulatory events from specifically LexisNexis on a daily basis. And let me then actually open up and discuss how regulatory events, are imported and managed within the solution. Okay, and this is an example of one of those regulatory events. This comes from, LexisNexis, and again, you don't have to do anything. There's no manual effort involved here. It is a automated import function that runs on a daily basis. You can assign ownership to the specific regulatory event in context of a specific, group or team that needs to review this regulatory event. And then, very important, you also get from LexisNexis whether this is, informational. Do you actually have, actions that's required, or is it simply news? Obviously, the moment you start to see regulatory events which is already flagged as actionable, those are priority events to start to understand the impact. You also then get, from LexisNexis, your impact on the obligation statement. Again, now having access to that full benefit of interpretation and guidance that you get from the data. You can also manage the effective date, of these regulatory events. And ultimately, when we look at now assessing, the impact of this regulatory event, we can create what's called impact assessments. And I'll actually quickly show you what that allows us to do. Now, this is an example of those impact assessments. Again, we can link our impact assessment to a specific regulatory event. We can assign it to a specific, assessor to determine the impact. And then, very important, you can perform an assessment and actually determine what should be changed within your organization, your control environment. Do we need a control change? Do we need new controls? Do we actually have to, update our processes or policies even? Or will we actually be accepting risk of not doing anything in context of dealing with this specific regulatory event? So you have the full benefit, from a integration perspective of importing your regulatory instruments, all the related obligations for those regulatory instruments, and then on a continuous basis, effectively daily, we also import all the LexisNexis regulatory event information, and then you have the ability for those regulatory events that you assess as impactful to the organization, actually then run and do a specific impact assessment and determine what's required. You can also raise issues. So if on the back of a regulatory event, you actually want to escalate this further in the organization, a lot of organizations have dedicated issue management processes. You can create an issue record and then facilitate that directly within the organization. Good stuff. Also, a quick reference to how do we actually link our obligations to our control environments. You would remember this obligation that we specifically showcased, and you will then see the ability to link an obligation to a specific control objective within the organization, and also a specific risk statement within the organization. And this is actually where you move beyond just establishing those registers, and you actually start to link the register content to your internal system of control, to your risk environment. And now you have full integration capabilities, from a ServiceNow IRM perspective. Good stuff. That's effectively the showcase. There's a lot of capability within the solution. Again, this is specifically focused around integrating with LexisNexis Content. Over to you, Paul.
You've done well for time, sir.
Yes.
All right, so we do have a little bit of time left. I'm just going to take control back and show my desktop. Okay. Juggling screens. So yeah, we've got a bit of a Q&A. I haven't seen any questions at this time on the chat, but it's not too late to put any key questions down there. However, as professionals, we've pre-canned some questions, and I don't intend to use them in that order, but maybe I'll pick on number 4, first of all. How will we know, and maybe I'll direct this one to Kieran, how will we know that a piece of legislation is or has been updated?
Thanks, Paul. And I'll probably start the answer on this, but part of it will probably be on the system side as well. So from the LexisNexis side, we do a number of things. So whenever a change is made to legislation and system, we import what we call a historical note. So if we make a change to an obligation, so if that's adding new content or replacing a piece of legislation, then there will be a historical note attached to that obligation to identify that that a piece of legislation has been updated. And then on the system side, it will be a question of flagging that the obligation has been updated. But basically, it's something. The point from our side is that whenever there's a change to legislation, so if something is amended or repealed, there are a number of different ways that you can get the information, whether it be from an alert or from the other material that's associated with the obligation.
Well, let's flow straight on to the other one, number 5, which is what kind of advance notice do we get? Do we get it on the day, or are you way upstream?
How far upstream are we talking here? No, look, it's a difficult question to answer in a general way, because if you look at the amount of regulatory change we've seen in the last 9 months or so, it's been, I'll use the word absurd because I use that all the time. In terms of what kind of advance notice we're going to give across Australia and internationally, it's not going to be one I can fully answer. It'll take us all day to get through what the differences are, but it's going to work slightly differently in the different international jurisdictions that we have coverage in. Yeah. If I take the Australian example, alerts are drafted and sent out as soon as practicable after the relevant change stage. When I say change stage, If we follow the legislative process all the way through, you will get an FYI alert at the consultation stage when the bill is tabled in Parliament. If the bill passes, when it's assented to, when it's proclaimed to commence, which is often through a separate commencement proclamation. And then each time a substantive part of the amendment or new act takes effect. And as I said earlier, you can have very deconstructed commencement dates. So different parts of the legislation can take effect at different times. So alert will go out at each of those points. And as I alluded to earlier, there's a unique identifier that's associated with that alert. So any future changes will have that unique identifier as well. Now, the overseas, these phases aren't going to be exactly the same, but we will send out alerts for comparable stages in the legislative process. So there's plenty of advance notice of change where that advance notice is actually available. So if anyone has a specific question about how it works in a certain jurisdiction, please do get in touch.
That sounds like a really good long-range radar. So looking at the other side of life, Andre, pull in this information and this content and these events and updates into ServiceNow. Talk to me a little bit about the integration and how often that's refreshed.
Thank you, Paul. So from an integration perspective, there's not really any effort involved. From a customer perspective, the integration takes care of the initial upload of content, based on what the customer has subscribed to, with LexisNexis. That import happens, upfront and is effectively done to establish your instrument register, obligation register. And then ongoing, which is every 24 hours, we actually go out and we collect from LexisNexis the latest regulatory events. So every 24 hours, we actually update the regulatory event register, which includes, mapping back to the relevant obligation and, instrument directly. But again, there's no effort involved, from a customer perspective. The integration takes care of, that continuous updating that is required. Yeah.
Cool. And so when a customer may subscribe to more content from LexisNexis, that again automatically flows through?
Correct. So the moment that subscription is, let's say, live now, the next pull that we do, which is again every 24 hours, will bring in that content automatically. Yes.
Sounds great.
It is. If you look at, if you look at, anybody in the compliance space the last 20 years, this is such a big pain point, trying to stay on top of regulatory change. Currently, a lot of organizations have Excel and email to try and track all of that, and that is just no ways in 2020 and going forward is that sufficient. You need a system like, ServiceNow RM that integrates with LexisNexis. Yeah.
And the reporting and transparency must be a big boon to people as well. What advancements are you seeing in that space? Are there any innovations coming from Enable, perhaps?
Yes. So from a ability to really instrument and, and I'm going to use the word enable, your first line of defense. We've actually developed a specific first line of defense risk portal that gives you access to capabilities that, adds to the out-of-the-box capabilities in context of a workspace, which is effectively the life of a typical line one risk manager, on one page in ServiceNow. So you don't have to go and navigate, to different modules to find out, what tasks you have to complete and, manage and track. It's on one page, including, additional risk assessment capabilities like risk bow tie, which is an additional component on top of that. And then the continuous enhancement, of driving a lot of web-based, technology where it's easy to access the information, irrespective of the device. If you're in transit on the train, you have an iPad, you can log into your workspace and actually work from the iPad. You don't always need to have access to a PC.
Yeah, I've seen the bow tie at work. It's really quite something. So, Kieran, tell us what new modules you're planning over there at LexisNexis.
Top secret, can't tell you. No.
Okie dokie.
Thank you, Kieran.
No, we are planning our 2021 roadmap at the moment, but as with all things, it's subject to change, and it's been a year full of change over the last 12 months or so. For example, this year we pivoted to build a biosecurity module for Australia and New Zealand directly in response to COVID and the COVID pandemic, which was to help customers to map their ever-changing public health requirements. We've also got a new sanctions module that is coming in the next couple of weeks for Australia. Now that's going to give more granular coverage of sanctions requirements, so both here in Australia and internationally, depending upon your operation. So looking at specific regimes out of the US, the UK, and considering what the implications of those regimes might be for Australian businesses. For next year, we are going to be deepening and broadening our coverage. So in new jurisdictions and new regulatory areas, not just in Australia, but across all of the jurisdictions that I've already identified, and potentially some new ones as well. So we would love to hear from you all if there's a particular jurisdiction or a particular area you'd like to see next.
I know from my own experience where there's been a demand, LexisNexis has, we've identified that LexisNexis has responded with additional content, which has been really good to see. So I think, this is an organization that takes that demand on board and responds to it. So well worth taking Kieran up on that. So, let's go to the question at the end. With the Brexit transition period nearly over, what assistance do you provide to those companies attempting to understand that impact?
Oh, very technical. So as I alluded to earlier, Brexit is going to make things a bit more complicated in the compliance space. A bit is probably an understatement, because depending upon what countries you conduct activities in, we go back to that definition of conducting activities that I talked about at the very beginning. What you're going to need to do is going to look slightly different. And that's compounded in the aftermath of Schrems 2 and the invalidity of the privacy shield. So there's more going on in the context of the Brexit transition than perhaps anyone was really expecting. And a lot of what is actually going to take place is still not known. There's a lot of things that we're still expecting to see, even in the next few weeks. Now, we've commenced preparing updates for our UK privacy module, so that it refers to the UK GDPR and to properly explain the different times that the EU or UK regime will apply. I guess in short, we give advance notice of the changes to compliance requirements and update, and we'll be updating content to reflect those changes on an ongoing basis. There's a lot that has been going on and being sent out particularly in the last few weeks. The other area that I've seen a lot of change in is in the sanctions space. So in the UK, with the UK attempting to replicate relevant UN sanctions for its own context, there's been a lot of activity in that space as well. So a lot of alerts have gone out for our customers to give them that advance notice of when those regimes will take effect and when they should refer to them.
Yeah. Okay. Thank you. Last call for any questions in the chat, but I think, from a licensing perspective, which is the dull bit, but licensing for LexisNexis is directly with LexisNexis, dead simple. As for ServiceNow, often that is directly with ServiceNow as well, and Enable, as I say, is a lead partner with ServiceNow, so we can assist people to understand what licensing is required. And our role is then to make sure the implementation goes well and you get the outcomes that you richly deserve. So keeps life reasonably simple. Gents, before I move on to the close, any other questions or even comments from yourself, Andre, or yourself, Kieran?
Yeah, I think it's important to, make sure people understand that if you look at quick wins from an implementation perspective, implementing the LexisNexis content within ServiceNow IRM is by a long shot the fastest quick win you can ever get. You can effectively, in as little as 2 to 3 weeks, you can have a draft register available, because the automation does so much for you. The work obviously still comes in, and then understanding the impact to the organization. But this is a quick win capability. This makes a big difference. What we've also seen organizations having 6 to 7 people trying to manually manage regulatory change, and they've been able to reduce that to 2 or 3 people and repurpose the work of other people. So this is a big, quick win, immediate, relief from, the challenges around trying to do this manually.
And from my experience, that's not necessarily a threat to headcount. That's much more a case of being more proactive and getting ahead of the curve, not just reducing the team size. So just to make that clear to everybody.
Yeah. And the whole idea is repurpose. So now we focus on, understanding risk assessment better, instead of trying to update an Excel spreadsheet and tracking through email. That's why, that's another key benefit.
Not very fulfilling either. But what are some of the challenges that you've seen? I mean, it's all very positive and there's lots of positivity in this session, but what's some of maybe the call outs, Andre, that you would say, this is a common pitfall and you should avoid that, and how?
So I'll share with you what we're seeing is that this is such a big step forward that you need to also address the politics associated with this and the organizational change management. Because the fact that we now have a workflow, a digital workflow that allows you a system of action and a system of record, means transparency and accountability can no longer be, massaged like, what you can do in an Excel spreadsheet and via email. This is a system that really, shows people where the work sits, what's the progress on that work, provides all of that reporting. So again, it's not necessarily technical, the challenges, it's really how do you make sure that people can start to use the system and they're properly, set up, they're trained sufficiently, to use the system.
I think one observation I've made is with the introduction of, the world of DevOps and continuous release of updates to services and applications, then the only way to survive is automation. When you're moving from maybe 5, 10, 50 updates a day to hundreds and thousands, then you have no option but to look at a way to automate these controls.
Yeah.
And that's really going to bite down, I think, in 2021, is my observation. Cool. Okay, well, let's move on to the very last piece, which is additional information. There's plenty of links that we've provided in this pack, and we will be emailing it to the attendees today. So you can see lots of links, both from LexisNexis as well as ServiceNow, and obviously you can hit the enable site as well. But otherwise, unless there's any last second questions, which there is not, then we will close the session. With plenty of time. Normally these things do lap over a little, but it'll give people 5 minutes for their lunch. So thank you very much for everyone's attendance, and we'll be emailing out some links to the recording and the slides as well. Thanks to Kieran, thanks to Andre, a pleasure as always, and we will close the session. Thanks everyone.
Thanks, bye-bye.
Thank you, bye-bye.
Thank you.